Welcome to the first episode under the new rebranded podcast, My Two Cents, a Zambian case law podcast with me, your host as usual, George Chintankwa Malipilo. So today's case is the Supreme Court case of Patrick Sakala versus the people. This was a reported case in the Zambia law reports at page 205. Now, for some of you that read these cases, if you find the word Z.R.205 CS, that means Zambia Law Report at page 205, Supreme Court. That's what it basically means. So it is a reported case in the Zambia Law Reports. You find it always at page 205. Now, the issue in Patrick Sakala versus the people looks at the type of evidence that is acceptable in court. Now, for those of you that are lawyers, or students, because the Law Association of Zambia Act says students are lawyers, you will come across what is known as evidence law. Now, evidence law looks at facts, how certain facts are presented. Now, when facts are presented in evidence, they are either by a witness. Now, the witness is either one who saw the actual event happening, and there's what is known as indirect evidence or circumstantial evidence. Therefore, the case of Patrick Sakala versus the people was asking the question, can you convict an individual who was never seen by anyone to have committed the offense, but they are facts that are of relevance to the issue, such that if you put these facts together, at the end of the day, you would be more than sure, or like the courts like to say, the evidence is so cogent such that it has been removed from a realm of conjecture, and that the only inference possible is that of the accused. So basically meaning, from all this relevant evidence, can we say for a simple fact that this individual and nobody else killed this person, despite there being no eyewitnesses? The brief facts of the case of Patrick Sakala versus the people was that this was an appeal from the High Court. After the High Court found Patrick Sakala guilty of murder. The brief facts of the case were Patrick Sakala had met a child and a woman. The child was aged 4 years old. The woman, the child, and Patrick Sakala traveled together for about 2 hours. In that duration, Patrick Sakala thought it was appropriate to propose to the woman, and the woman said no. She refused. It is after this incident that Sakala decided to severely violate this woman. Not the words violate, sorry. He beat her up to the point that she was unconscious for 8 hours. Now, when the woman regained consciousness, her suitcase had gone, and she found that her child had died. Now, this is where the issue is about. The dispute pertains to whether Patrick Sakala had actually killed the child or not. That was his argument. And on his appeal to the Supreme Court, he was arguing to say, look, there is no direct evidence connecting me with the offense. And there was also no medical practitioner present to look at and assess how this child died and the likely possibilities. So that was his argument. However, when the court made their judgment, they made reference to what the High Court had observed on the issue of whether the child had actually been killed by any other person apart from the accused. Now, let me just go through what the Supreme Court said in the assessment. I'm just trying to find the actual provision, so do bear with me. So the Supreme Court began by saying, as there was no eyewitnesses to the killing, circumstantial evidence must once again be called in aid. So you can see from this statement itself that circumstantial evidence is indirect evidence. The courts are not trying to basically determine the fact in issue from that circumstantial evidence. No. Those events are admissible and are being used as a way to determine whether or not this person actually committed the offense. So it helps the court into arriving at a decision. So the court goes on to say, having battered the child's mother and stolen her suitcase, he had the motive. I cannot see a third party, a stranger who had nothing to do with the battering of PW1, which was the woman who was beaten by Patrick Sakala, who was a witness, who had nothing to do with stealing PW1's property, simply coming upon a little boy alone in the bush near where his mother lies unconscious, and forthwith proceed to take a belt from the woman and squeeze it tightly around the neck of such a child. So this was the extract that the court were reading from the High Court judgment. They went on to say, we agree that the circumstantial evidence implicating the applicant with the crime charged is overwhelming. He had the opportunity and the motive. It seems probable to us that the beating up the child's mother and left her for dead, the applicant must have decided to take the child's life in an effort to eliminate the chances of being later identified by the child. From that passage or extract, we are now able to see the judgment of the Supreme Court was that circumstantial evidence in this case was of vital importance in coming to a conclusion that Sakala had actually killed the child. Having left the mother unconscious, he must have had a motive, and the motive was to erase any evidence whatsoever. The other evidence was that Sakala was the only person at the time with the child and the mother, and also Sakala himself decided to start distributing these clothes to people near the village after the woman was left unconscious. So all that put together could obviously come to one conclusion, that Sakala was guilty. Looking at it from that angle, that he was guilty, despite there not being eyewitness at the actual time the crime was being committed. So from all this, what you could actually learn is, in law or in the evidence of law and practice, there is what is known as oral evidence given by a witness. One, it is direct evidence. When a witness is called to the dock, they will be asked to, I swear to say the truth and nothing but the truth. They will then be asked what they saw. The witness at that particular point in time will then tell the court issues relating to what they saw. Now, direct evidence is not the only evidence. If we read into the case of Patrick Sakala versus the people, we are now initially saying a court can convict when there was no person who actually perceived with any of their five senses: hearing, touching, seeing, and the other senses. The court can actually rely on relevant information that is of importance to the case. And that relevant information, if put together and not seen in isolation, and if at the end of the day, having looked at all that evidence and having excluded all irrelevant substances and irrelevant information, if it can be seen that the accused and no other person actually committed the crime, then they can convict that person. Now, it is very important to note that circumstantial evidence is not on the court to prove. It's still the duty of the prosecution. The prosecution must remove the case of what is known as a realm of conjecture, which is a realm of doubt, such that when we look at the evidence, the judges look at the evidence, they will say, upon looking at all this evidence, there is no other person that could have done this apart from the accused person. So circumstantial evidence in itself is considered to be the greatest form of evidence, as most courts say. But what this also brings out is that in order to convict on circumstantial evidence, there has to be an inference that must be concluded. That the only inference or cogency at the end of the day is clearly showing that of the accused. And the court will only convict on evidence that only points to one person and one person only. Hence the phrase that they used was, the circumstantial evidence was so cogent and compelling that no rational hypothesis other than the murder could the facts in this case be accounted for. So from this, what we learn is, as I keep on repeating, the emphasis of circumstantial evidence. You need to understand what is circumstantial evidence, which is basically indirect evidence. And how does it arise? The fact that there is no eyewitness. However, there are events which are of relevance to the matter. It shouldn't be anything, events relevant to the matter. In the case of Patrick Sakala versus the people, the events relevant to the matter were: 1, he was the last person to be seen with the woman and the child. The woman was left conscious. He then decided to start giving away the suitcase with the clothes from the woman who he had consciously assaulted. The belt that was used to kill the child was from the mother's dress. And who else was within the perimeter of the bush? Why would the third party come and just kill a person, a child, for no reason at all? They therefore found him with motive. So all those are events. No one saw those events of Sakala killing the child, but they were events that were of importance. Sakala left the woman unconscious. She woke up, she found the child. The fact that there was the giving of these clothes. So, in conclusion, the case of Patrick Sakala versus the people is trying to tell us that circumstantial evidence is as much evidence as direct evidence. That you do not need to actually convict always on evidence where someone had actually seen the event happen. That you can actually convict someone on indirect evidence. And also, it does not need to have a medical practitioner or an expert there to tell you what happened. As long as you can show that this is what happened and you've removed the case out of any doubt whatsoever, the court can convict on that particular type of evidence. In a nutshell, indirect evidence is used to convict accused persons if the right type of evidence is available. And in closing, for those of you that have difficulties understanding circumstantial evidence, it is simple. Indirect evidence that was perceived by persons who were not there when the crime happened, but there are certain events before and after the occurrence of the event which render them to be of particular importance. So that is it for today's topic, which was the case of Patrick Sakala versus the people. I've been your host, George Chintankwa Malipilo. Thank you for tuning in, and I will see you